I'm here with Brendan Dillon, Principal of Dillon Solicitors in Rathfarnham, and we're going to discuss some recent legal developments which impact on all of us. Brendan, you're very welcome.
Thank you, Sybil.
Let's start off with the 2014 Companies Act.
Yes, Sybil, this is an enormous piece of legislation, and in the short time it's obviously very difficult to do a whistle-stop tour. But what directors of companies need to be aware of, that there are two new forms of companies that they're going to have to decide, are they either what's called an LTD company or a DAC company. And as I said, it's impossible to go into too much detail, but directors need to make that decision by September of this year, so that's obviously very important. The other few changes that were brought by the Act that I'm going to talk about are, one, companies can now only have one director. Previously they had to have two directors, so that's a big change. One new introduction which directors need to be very careful about is that the new Act brought in 8 new what are called fiduciary duties, which are really duties of good faith to the company and to the shareholders in the business, and they're certainly duties that directors need to familiarise themselves. There are many other changes in the Act. It is really a very lengthy piece of legislation, and one that directors need to be very familiar with.
Okay, let's move on to family law now, because there have been changes over the last few years.
Yes, Sybil, and as recently as a few months ago, there's a new Children and Family Law Relationships Act which has gone through the Oireachtas, and while the children in a marital breakdown have always been the central focus of a court, this piece of legislation puts children very much at the forefront of a family law breakup, and uses language such as the best interests of the children, which is a guiding principle for the courts. It has also enshrined the view that the voice of the children should be heard, so it is going to be interesting to see how courts interpret that, as to whether they actually speak to children directly or use expert reports in the form of child psychologists, etc., to assess the children and what is in their best interests.
Let's stay with family law, because there has been some clarity in relation to cohabitees' rights.
Yes, there was a recent decision by Judge Mary Baker in the High Court a number of months ago, and the cohabitance legislation came through in 2011, but there's been very little case law in relation to what happens if a cohabitee dies, and this case has been very useful in establishing what a surviving cohabitee has to do to prove that he or she was in an intimate relationship with the deceased cohabitee, and also the tests that will be applied by the court in assessing what entitlements the cohabitee may get out of the estate of the deceased cohabitee. So it's a very interesting case, and one that I think will be used in claims by cohabitees in the coming years.
Okay, let's move on now to the rights of tenants in residential properties.
Well, of course, Sybil, the issue of rising rents has been one that has been exercising the thoughts, particularly of tenants in recent times. So these changes have effectively created a freeze for 2 years, which means that a landlord cannot increase the rents for a period of 2 years. Now, there is what is called a sunset clause, which means that in 4 years' time, that period will reduce to 12 months, so landlords will be able to increase the rent again within 12 months. There are the new legislation and regulations have brought about quite, I suppose, far-reaching rights for both tenants and indeed landlords, who can now enforce decisions of the private residential tenancies boards through the district court, which was something that wasn't there before. And I suppose the biggest other change is the fact that deposits now paid by tenants will be paid into a deposit fund held by the PRTB, so landlords will have to apply to the PRTB so that these can be refunded back to the tenants at the end of the tenancy. That's likely to cause a bit of an administrative nightmare, but it's something the time will tell how it works out.
Okay, how about in relation to property transactions? Is there anything now that buyers need to be aware of?
Well, Sybil, in Dillon Solicitors we act in behalf of a lot of vendors and purchasers, and one of the areas that has been creating a lot of difficulty is a regulation that was brought in by the central bank early last year, which requires that when buyers are drawing down loan checks, they must have a valuation carried out no less than 2 months prior to the completion. Now, most valuations are carried out when they're getting the loan offer, and as transactions can sometimes take more than 2 months, this is causing a huge headache for buyers, and they're having to get another valuation very shortly before they close. So it's something that buyers need to be aware of, because it can slow down the transaction.
Okay, let's move on now to the recent changes in the area of personal insolvency legislation.
Yes, this legislation, which was originally brought in a number of years ago, reduced bankruptcy from 12 years down to 3 years. The recent amendments made by the Minister have reduced that down to 1 year, which is the period which has applied for many years in the UK. So I think we're going to probably stop the trail of people going to the UK or indeed to Northern Ireland to declare themselves bankrupt. There is another important provision that in relation to what are called debt relief notices, which are people that have no assets but just a certain amount of small debt. The threshold for that has been increased from 20 debts of €20,000 to €35,000. So they're quite far-sweeping changes that I think will have see a huge amount of business being done by the Personal Insolvency Service.
Okay, and finally, the recent changes in relation to vulnerable adults.
Yes, there is a new Assisted Decision Capacity Act, which has just been signed off by the President in December of last year, and this is going to bring great relief for people who are looking after vulnerable adults, because there's been huge uncertainty in relation to what decisions people can make and whether they are capable of making decisions or not. First of all, the Act creates a presumption that vulnerable adults are capable of making decisions, so it'll be a matter of medical evidence to state that that is not the case. The Wards of Court Office is going to be done away with and replaced by a new Office of Public Guardian. And there are a number of other changes in relation to enduring powers of attorney, which will allow attorneys to make decisions in relation to healthcare issues. So again, quite a wide sweeping piece of legislation, and I think one that it will be very welcome to people who are looking after vulnerable adults.
Okay, well, Brendan Dillon, many thanks for that update.
You're welcome.